The House. The question is that the motion be agreed to.
Speaker.
What's his name? I call the honourable member David Clendon.
Thank you, Mr. Speaker. Mr. Speaker, we have objected and opposed this bill and will continue to do so clearly. And as I began earlier today, we are opposing this on both issues of process and of substance. In terms of process particularly, we just heard from the Minister that all parties were given advance copies of this bill, some more in advance than others. We don't consider getting one single hard copy of a bill at 10:30 the night before it is due to be debated to be particularly advance notice. It clearly was inadequate for us to come to establish or to do any substantial investigation, consideration, any consultation within our caucus, or indeed to obtain confidential but skilled legal advice. There was no forward advice given to us. There was no attempt to streamline the process of this bill through the House by getting the buy-in of all parties in advance of it coming to the House. I made this point in my earlier contribution that had the Greens been taken into the confidence of the government at some reasonable time in advance of it being tabled, we may well have been able to negotiate an outcome that would not have involved the process that we've gone through today. Mr Ardern, in his contribution to the House, put a challenge to us, and he wondered why it might be that we were not taken into the government's confidence in this matter. And I have actually given that a wee bit of thought in the intervening couple of hours, and I've come to the conclusion that the reason the government is unwilling to take a smaller party, an opposition party, is perhaps that the government has not yet grasped the reality of MMP. To not give some reasonable advance notice to a party that I can proudly say has proven its ability to accept and to respect a confidence, I think indicates that the government is locked into the notion of a two-party adversarial system. And I do believe that the work of this Parliament would proceed more smoothly and get better outcomes if members on all sides recognised that we are in a new context. The issue of retrospectivity, effectively one major component of this bill is that it will be retrospective. It will, if you like, validate the actions of the police between October 2008 and 2010. It will protect, we are told, the Crown and the police from any possible liability, from litigation, from appeals of convictions that may have depended upon information that was retained illegally. And I do stress the point that we know the police were acting illegally. They did not know that. There was no reason they ought to. I make no criticism of that action. I think what we have to respect, however, is that retrospective law is most often bad law. There are very clear situations where it ought to be opposed, and we will recall there was a quite recent example. The Greens had no opposition to the issue of the constable oath. That was a very finely nuanced wording which put the possibility out there that constables did not have the power to arrest. We had no objection. It was very clear-cut, obvious. This is none of the above. This is far from being a similar case. Retrospective law is it's anathema to this House to the extent that it appears in our New Zealand Bill of Rights Act, protections against that. And I will quote from the Act. The Bill of Rights Act says no one shall be liable to conviction, no one shall be tried or punished for it again. Effectively, there is a message within that. It is clearly codified in our law that we do not change the law after the event except in very exceptional circumstances. It may well be the case that this law needs to be changed. There is no justification, however, for the way in which it has been done. To put it through without the benefit of legal advice or opinion, without exposure to the public gaze, without even giving participants in this chamber reasonable time to consider their views, to gather evidence and to undertake some sort of commentary on it. We are told that the Crown is at real risk of some multi-million dollars potentially from litigants who might seek to appeal against convictions. I think the scale of that risk does not justify the degree of speed, the secrecy, the urgency of the passing of this legislation. A contributor from the Labor Party referred in jest clearly to 1 trillion cases out there where young people, their lawyers, might choose to attempt to pull back a conviction, to have a finding overturned at the youth court level. I reject that completely. We only have to use our common sense to think through there would only be a very few cases out of that 1,200 or so that's been talked about where the evidence solely rested, where the finding rested solely on one piece of evidence that had been retained, be it a fingerprint, a photograph, whatever it might be. They would be vanishingly small where there would be any opportunities, even for quite an opportunistic lawyer, to go hunting to have a conviction overturned. I think if this House makes mistakes, and it will continue to make mistakes because we are all human beings, and long may that continue. However, mistakes carry cost. We've heard several times the explanation that where young people have committed offences, they must be punished for it. If this government puts itself at risk of some cost because of a mistake made, so be it. There is the degree of secrecy, of urgency, is not balanced by the degree of real risk of the likelihood of appeals against this. I think we heard a very revealing commentary from the Minister in her contribution, to the extent that she indicated that these young people who are offending can't be helped unless they go through some process like a youth court. And I actually reject that. I think we can do a great deal to help our young people stay out of the courts, keep away from this register, away from the notice of the justice system, if we invest heavily and well at an earlier stage in their development. And we could have a very different debate today about the $1.2 billion in the corrections budget, for example, that could be spent in so many better ways that would absolutely reduce offending, youth offending, adult offending and recidivism. I'll finally say I'll revert to the challenge I put out. 10 months ago, the police realised that they had been getting it wrong, albeit no blame to them. In the intervening 10 months, clearly, they have not been retaining information. They have been acting in accordance with the law as it is currently written. The challenge I put out, where is the evidence that that has caused a real problem? We have heard that in the absence of the retaining of the information about these young offenders who have been found guilty of some offence, that there will be major and serious repercussions, that they will get away with further offences, that there will be significant adverse effects from that. Where is the evidence? Not one speaker from the government pointed us towards anything, any information from the police that said that their job actually got harder, that they had a more difficult time locating offenders, that they have a more difficult time proving who had committed some crime against the local society. I'm very surprised by that. I would have thought that would have been, for me, a very compelling argument if I had a document giving evidence from the police that said their job was made more difficult, that they had more difficulty locating offenders or getting orders against them in the youth court or indeed at the district court in the absence of being able to retain that information. And I see there's a certain quiet has descended. I do hope from the government's contributions that we will hear that such evidence does exist, that there is some empirical study has been made, that in fact this error that apparently was made did have that adverse effect over the last 10 months. We know that young offenders do tend to, if they're going to reoffend, they tend to reoffend quite quickly. They are captured in some sort of cycle of offending. And I would advocate that if the seriousness of this error was such as has been put to us today, that we would have seen evidence of difficulty experienced by the police. And I look forward to hearing that evidence from the government. Kia ora.
Speaker?
I call